Right, lawyer and public affairs analyst Libros Oshoma joins us now to bring us up to speed and give us insight into some of these implications. Libros, it's good to have you join us right now.
Yeah, good morning.
Now, when it comes to the powers to disqualify a political party from conducting an election, from the tribunal saying that INEC doesn't have the power, we saw in the case of Zamfara and River State in the last election, APC was disqualified for not meeting the time, and they stood disqualified. Make us understand what's the difference between that and this.
Thank you. Good morning. And that's why for people like me, I would believe more in the tribunal's chairman's dissenting judgment, because this judgment runs contrary to the position of the Supreme Court in Zamfara, in the case of Zamfara. Because if you look at the meat of the case, really, INEC said that INEC positions the fact that the candidates, as at the time the candidate was nominated, he contravened Section 177B of the Constitution that requires each candidate to be up to age. That's at the time the candidate was nominated, he was 34 and not up to 35. And INEC drew the attention of the party to this abnormality. And then the party subsequently on the 23rd of September or so sent another name. As at 24th of September, the time for substituting candidate had lapsed. The time for, by INEC guideline, the time for substitution of candidates lapsed on the 13th of September. And so to that extent, INEC did not, the position is, INEC did not disqualify the candidate. INEC only rejected the nomination. And so the question is, some people will say it's a question of semantics. The question is, does INEC have the power to enforce its guidelines? The Supreme Court in that Zamfara case you cited said INEC has the power to enforce its guidelines. And so if INEC has the power to enforce its guideline, any party that did not meet INEC guideline, can that party say it was excluded from participating, that was disqualified, as the tribunal had heard that the court, INEC does not have power to disqualify? The answer is a no, but the matter will still get to the Court of Appeal and then subsequently the Supreme Court. So let's hear what the Supreme Court has to say, because INEC is an administrative body, and then they also have powers to take administrative decision, which the court can query. So this is just a court of first instance, and it's not, a lot of people also, some lawyers also have argued that, yes, INEC does not have powers under Section 30 or Section 21 of the Electoral Act to disqualify a candidate. This is not a question of disqualification. This is a question of a candidate excluding himself from the election by not fulfilling the requirement of the election. It's like you have a certified lunatic submitting nomination. Does INEC have the power to say, no, you have not met the requirement? INEC does have the power. The Supreme Court had ruled on that. So if such a candidate, by not fulfilling the laid down requirement, decided to exclude himself, that does not mean that this candidate was disqualified, as erroneously held by the tribunal in the judgment of two members against one.
Boris, one question analysts are thinking about right now, ever since they heard the judgment, is as to whether the All Progressives Congress can return to the ballot. Is this a possibility?
No. It's a no. Because the case of the All Progressive Congress, it's a different matter. And the Supreme Court had said, by virtue of the provisions of the law or the Constitution, the All Progressive Congress has no candidate in that election. And so if the courts, let's assume the matter gets to the Supreme Court and the Supreme Court says, go and redo the election. Redoing the election means that with those that, participated, according to the judgment of the Supreme Court, participated ab initio, because by that judgment, it is presumed that APC did not participate in that election. And so the APC cannot subsequently participate. Also, more so, the time for substitution of candidate has lapsed. INEC had not opened the window again for substitution of candidate. So you cannot substitute that candidate that had been disqualified by the Supreme Court when the time has lapsed. So that's basically what should happen.
Just on Saturday, the Governor Doyedire, was in church, of course, to celebrate and jubilate that he had actually, he remains the governor of the states. But now that another judgment has come out to say that fresh elections had to be conducted in 90 days, how do you think this all play out? Because it's a bit confusing for the common man on the street. You have one governor today, you have another governor in the next coming days.
No, not, and that's why the Electoral Act is very clear that when a tribunal delivers a judgment on a matter, provided that the party concerned appeal that judgment within a time, that there is no need to file application for stay of execution. That judgment automatically stayed as that, and the governor will continue to occupy office until the appeals is exhausted. And so this is what we call the first lap. You still have a second lap at the Court of Appeal, which will be decided within 60 days. And then you have the last lap at the Supreme Court, which also will be decided within 60 days. So it's a judgment of 2-1. And so also at the Court of Appeal, it might go either way. And if there is still an appeal, that judgment will still be stayed until the appeal at the Supreme Court is exhausted. So it's not here to huru for those who are celebrating the ouster of the governor. And also, since the governor has appealed, there is really no cause for him to worry until it is all over.
All right, Libros, try to enlighten us a little bit. It was just a few days before that time. The tribunal upheld the election of Governor Doyedire, and then a few days after, we had this. This controversy is one thing laymen like us cannot really understand. Please, can you enlighten us?
You see, after every election, if each party that participated in the election, it is typical for us to go to court here. And so you have various political parties that participated in the election contesting the outcome, disputing the outcome, one way or the other. The one that was nullified or dismissed on Saturday had to do with the conduct of the election proper. And so the court, in its wisdom, heard that the petitioner had not been able to prove their case to warrant a judgment in their favor. So that is a matter filed by a different political party. But for this one, so at the tribunal, you can have 5 cases, you can have 10 cases against the winner of an election. And so the court will take all of the cases on their merit and deliver judgment on all of them. And so for those, for the candidate disputing the outcome of the election on the ground of irregularities, the court had ruled that the election followed, substantially complied with the provisions of the Electoral Act. But the issue that the court decided yesterday was the issue of unlawful exclusion, that a candidate did not even participate. He said, because you also understand that by virtue of section 30 or 31 now, I think 31 of the Electoral Act, INEC does not have power to exclude any candidate from an election. And so the court said once a candidate is excluded, that election, what it means is that election didn't take place, is nullified. But here, the question is, did INEC exclude the candidate or rejected his nomination? These are the issues that the Court of Appeal will substantially decide. And then secondly, another issue that will come up would be whether the matter is a pre-election matter or a post-election matter. And then lastly, whether the judgment was delivered within the 180 days rule as provided by the Constitution. If you remember, the election was conducted in November 2019. And by virtue of the rule, judgment ought to have been delivered in May 2020. And so, since judgment wasn't delivered, those are another issue, because Kogi did deliver judgment in their own matter despite the coronavirus.
Yes. Of course, it's worrisome that we have to rely on the courts to actually give us a final verdict as to election matters.
Yeah, exactly.
Libros Oshoma, thank you so much for your thoughts on this.
My pleasure.